which I'm going to speak on outcome-based education and curriculum mapping in the light of National Education Policy 20. Before I come to the National Education Policy, which focuses primarily on the multidisciplinary approach, the one important aspect, it gives on the multidisciplinary approach. So we have been teaching more monodisciplinary, like legal aspect. So law, like constitution law, or any other subject, what has been said Roscoe Pond long time back in his writings in 1930, law in books and law in action. So integrated approach, interdisciplinary approach is important and which in some way reflected under the National Education Policy. The second important point which we have in our mind, that is outcome. Outcome-based education. What is the outcome-based education? What is the graduate aptitude when a student passes from the college? What is the outcome? And this, particularly in the national law schools, the teachers are extensively involved in drafting their syllabus. They have complete freedom to start a course, draft a syllabus, keeping in the outcome, objective of the course, learning outcome. All these things are very much in there because that autonomy has been given to the teachers. When we come to the university system, so colleges are affiliated. University is instrumental in drafting of the syllabus, and many senior teachers, they are part of the syllabus curriculum development and they draft the syllabus. So a large number of teachers are not part of the drafting of syllabus in there. But just think that if you become a part of the drafting of syllabus, how you should draft and how that particular course gives a lifelong learning skill to a student. Knowledge, skill, opportunity, these are the important outcomes. I say, students generally when you offer a course, they come and say skill, knowledge, job opportunities, and also other aspects are ethics, moral values, cultural perspective, diversity. All these things are very important. But most important, student, why a student wants to opt your course on a particular subject. So as I said, when I started, this I can say, based on experience in the national law schools, and many teachers are from the national law schools, you have plenty of opportunity. As in the first half, during the inaugural session, Yogesh mentioned about the one lecture of Professor Banker Rao in 2007. Means 2007, what has been taught, it registered in his mind, and he is still after 20 years. So there was no syllabus. A topic might have been given to talk about, and I remember sir was teaching prisoners of war. So prisoners of war a topic. So he might have delivered prisoners of war in a manner that has permanently registered in a student, and that is the also outcome of your way of teaching, outcome of your learning. So how you effectively communicate and how you establish. And that person sometimes, but if I ask sir or myself also, I want to teach a course on international humanitarian. Okay. So when you given law school gives you an opportunity, in 5 years you have 20 compulsory papers plus 4 clinical papers, 24 papers, you have a limited role to play. But 27 papers, particularly 15 to 16 law papers, you have full freedom to draft in the private university as well as the regular as well as the national law university. So when I joined in the NUJ, so teacher asked me, you teach any subjects which you feel comfortable. So when I started, I said, I will teach ICL, International Criminal Law. I taught a couple of new papers, human rights in business, ICL, refugee law, and other things. He had like how to map this syllabus, mapping of this syllabus. So I said, refugee law, I can finish in 1 hour. Entire refugee law, I can finish 1 hour, where you will get some idea, like sir has to. But to teaching refugee law, drafting a syllabus where students can get an employment in their institution, working in the field of non-governmental organization on the basis of the knowledge he has gained in the classroom. That is the objective of your outcome of your life. If you taught refugee law and same students appeared in the interview and he defended himself when some questions were posed to him related with the refugee law, whether definition, persecution, non-reformer, or any concept, he was able to answer. That is the outcome because you convey, he taught in a manner which is registered. So refugee law can be, so when it has been taught to me, you teach. So I thought, okay, how to teach 40 hours, how to teach 50 hours classes. So 1 hour, 2 hours, it's like, every time say, okay, I am expert. So I said, I read the refugee law paper in 1 hour classes. So I said, the fundamental principles of the refugee law can be learned in 2 hours maximum, you will get the fundamental principles. But when you teach in the classroom, so how to map the syllabus of 40 hours where teaching is detailed, exhaustive and useful for the student, that is the purpose. So you keep in the mind skill development, knowledge of the subject and mapping of the syllabus are very important when you draft the syllabus. So as a teacher, I will give you an example of how we progress. So when I started, I thought where to start refugee law? If I put a question to you, many of you will say that refugee law we start from the 1951 convention. So journey of the refugee law starts from the 1951 convention, which talks about the definition of the refugee and also the other aspects of refugee. The convention can be finished in 2 days, 3 days. So you started, so I thought now we go into the historical. When you make in the syllabus, there are 2 important things which you have to keep always in your mind. One is the historical development of a particular subject. Whatever the subject you find, you look into the historical journey. You may not be able to go into the much detail, but you can trace the journey. So when I started with looking into that historical journey of the refugee law, how refugee has been appeared the international discourse, then I found refugee appeared in the international discourse. Some of you may be aware, some of you may not be aware that the Nansen passport in 1922. So the journey started from 1922. And since 1922, different phases of refugee law. So I got the historical perspective, so students have not learned only the 1951 convention, he learned the journey of the evolution of international refugee law is there. And then you continue, so you have 3-4 classes on historical aspect, different phases of the refugee law, and then you go. So what you can also make a distinction, a phase which is ad hoc. The steps were ad hoc. The development of the protection of refugees were ad hoc from the First World War till Second World War. Even after the Second World War, it was more in an ad hoc manner. It was not in a concrete manner, ad hoc manner, because everybody thought about the refugee is a temporary problem. Even the convention which was adopted in 1951, it says, convention was adopted in 1951, entered into force into 1954. The convention has 2 limitations. One is geographical limitation and second is temporal limitation. The geographical limitation, what it says, everybody thought in 1951 the refugee problem is temporary and it generated largely because of 2 world wars. Had there no world war, then refugee would have not appeared in the war. So they said the refugee problem actually is historically linked with the conflict which took place in the First World War and Second World War. So probably any solution, it has to be ad hoc solution. So they say the convention, if you read, so then you have to be critical in looking into. If you read the convention, then you find that there are two limitations, as I said, temporal limitation and geographical limitation. One can devote a lot of time in the temporal limitation and geographical limitation by saying the refugee was never ever thought about a huge problem for the international community because they focused on the origin of the refugee. They said the origin and cause of the refugees is largely First World War and Second World War. You can also go link with the interdisciplinary approach. Historical facts also can be brought in this subject. I say the interdisciplinary approach, which are multidisciplinary approach in the syllabus. So one should also read along with the history books. When you want to, if you focus on only the legal aspect, you may miss some of the interesting fact which is equally important in a subject you choose to teach. So your such a subject will become interesting when you try to see what of this subject has some kind of influence in this subject. And it is today in the world we see a large number of university or teachers. When we talk about the environment, scientists are also doing environmental, economists also doing environment, history students also doing environment, and of course law students are also doing environment. So environment is not only the monopoly of the law students. If I am talking about the affirmative action, it's not only affirmative action is the law students. Political science students are also doing the affirmative action when it comes to the constitutional perspective. I say we have to integrate the approaches. So our study after the mapping of the syllabus, we have to integration of the different approaches in the syllabus. That is also very important. So when you devote your time, you do some reading on the other papers where you find some kind of useful point which makes your study more interesting in the classroom and also for the knowledge purposes there. So I said even the refugee, coming back to the refugee part, 1951 convention, it said it has a mandate to decide refugees only prior to the 1st January 1951. Convention came into 1954, but convention had a mandate. Convention had a mandate to take the refugees retrospectively. 1st January 1951 means after 1951 it has no mandate. So that is the temporal limitation. The second limitation, geographical limitation. So it says it applies to the European countries only. So there are two limitations in the convention existing. So when you are taking any subject, I am giving an example because I feel comfortable. So I am saying a subject I chose. So I said historical I have taken. History I link with the subject, and then I am also coming into the limitation existing in the convention 1951 and 1967. So a student can or a teacher can brought lot of new factors on the why it has been there. So when you look into the why temporal limitation, why geographical limitation, one has to go into the termites preparatories or drafting stage. So each institution, so when you want your syllabus, you must discuss about the drafting stages as well. If we are discussing about the directive principles of state policy, and you start only with the Constitution Article 36 and 37, without looking into what happened in the Constituent Assembly debates, you will miss number of important points. There are number of members, they say the directive principle state policy are equally important and it should be made attached with the fundamental rights. So in the time of drafting of the Constituent Assembly, there was a question on the nature of the directive principle of state policy. It's not easily accepted because we borrowed from the Irish Constitution and directive principle, but when drafting took place, that has become very important part and many says fundamental. So when you read Article 37 and if you teach the Constitution in the classroom, हम क्या पढ़ाते हैं आर्टिकल 37 में और डायरेक्टिव प्रिंसिपल में, we focus is a non-justiciable. No one can go to the court. But यहीं पर हम खत्म करते हैं. Article 37, and that become an important point. That is the outcome. We say in the class, the part 4 of the Constitution is non-impossible, non-justiciable. तो हमने यही सीखा है कि justiciable and non-justiciable. लेकिन अगर आप आर्टिकल 37 को देखते हो, if you look into the article 37 of the Constitution, it has 3 elements. Article 37 of the Constitution has 3 important elements. अगर हम article 3 in 3 elements को if we attach, well, article 37, if you read article 37, what you read article 37 and concluded the essence of article 37, it's a non-justiciable. And that become a common एक sentence में हम कहते हो. But if you want to emphasize, you know, article 37 also speaks about is a justiciability. If you say article 37, how? Because the second element of article 37 talks about is fundamental in governance of the country. जब आप article 37 पढ़ेंगे तो लिखा हुआ है कि fundamental, however this article is, the part is fundamental in the governance of the country. Okay, this is the second element of article 37. First, non-justiciability, however is fundamental in governance of the country, and then it ends with saying state has a duty to make a law for the implementation of the rights mentioned under the part 4 of the Constitution. So when state law बनाने लगे, स्टेट अगर लॉ बनाने लगेंगे अगर पूरे तो ऑटोमेटिकली इट्स लीगली बाइंडिंग. सो आर्टिकल 37 आल्सो गिव्स ए लाइट टू कन्वर्टिंग द राइट्स इनटू लीगल इन नेचर. बट हमारा खत्म हो जाता है नॉन जस्टिसेबिलिटी पे. सो यू हैव टू अंडरस्टैंड कि ऑल थ्री इंपॉर्टेंट एस्पेक्ट इज देयर. यू टेक द एग्जांपल ऑफ द वर्ड सोशलिज्म. After 42nd constitutional amendment, so what kind of socialist ideology we have? Whether the feature of the Indian Constitution was not secular, whether the feature of the Constitution was not socialist before 42nd constitutional amendment? Answer will be no. Constitution was secular prior to the insertion of the word secularism, and also the socialist constitution, because let's focus more on that particular thing. So you start, then when you teach, then you have to also elaborate what is the meaning of socialism or socialist state in the preambular context of in India. Whether it stands for the Marxist socialism or whether it stands for the Gandhian socialism. Whether it's a merging. So you as a there's a case decided by the Supreme Court of India where court has elaborated D.S. Nakala versus Union of India in 1983, where the court has talked about the implication of the word socialism under the Constitution. So it talks about some way balancing both. State, but it's not entire Marxist, it's a Gandhian and Marxist ideological combined in the Constitution. So we have to look into all these parts in a very careful manner. So what you are teaching, what students you are teaching if you say without going in the socialism, without defining the socialism, you say it is sovereign socialism. So you put a critical thinking in the students. You put why what has been, what was the status, if basic structure discussed in the 1958. Number of cases basic structure. Basic structure was not defined the way in 1973 in case 1 and 30. But the word basic structure appeared in many cases prior to the 1973 of the Indian Constitution. So 1973 it became much further. So when you go in the classroom, when you look into the classroom, when you draft the syllabus, you try to look into all these interrelated aspects, interrelated development in your syllabus. That is very important. And today, as a law teacher, any subject, so if I come back to the refugee law, we have seen history, we have seen the convention, then we look into the most important part, a country which you are teaching whether party or not party of the convention. So the third important aspects become whether India is party to the 1951 convention. That will become a part of your syllabus, the 1951 convention. So you discuss everything. Then you say how this is being, whether refugees are protected. So the third point you are focusing on the refugees, whether India is party or not party of the 1951 convention. And if not party, whether it's causing some harm to the refugees or protection to the refugees. That answer you have to look into. Then you go to the next stage, that is the fourth stage. Fourth stage you look into the how Indian judiciary has interpreted, how Indian judiciary has held the protection of refugees at the domestic level. So you come to the conclusion that refugees are, like we started from a landmark case which we say National Human Rights Commission versus Arunachal Pradesh, Chakma case, that is the 1996. National Human Rights Commission versus the state of Arunachal Pradesh. That case was decided in 1996 related to the Chakma's refugees in there. And then if you read that case, you come to the how citizenship is being granted to the refugee. So when you started, then it occurred to you the refugee, how refugee status is granted by the state. What are the laws we have? You start learning the Foreigners Act 1946 is important for the refugee. The refugee word is not used anywhere under the Indian Constitution. It's an alien. So Foreigners Act says, so Foreigners Act governs. So all of a sudden you have learned something different, domestic law related with the foreign national. So that you started adding. You got it this one through the case laws when you started looking into the case law. Then you also by chance you landed in the Citizenship Act. The Citizenship Act, how it grants the citizenship to the Indian. Then you have Citizenship Amendment Act. Then you have so lot of things you can add on your syllabus and end when you look into. And then if you how terms are whether the definition of refugees in 1950 convention is adequate or not, you look into that. So you see that if you, the point which I have highlighted step by step, it gives you sufficient scope to learn, teach a class of the 60 students for the 40 days or 50 days or 40 hours and 50 days. So mapping of the syllabus, how deeper you think about, how deeper you go in the syllabus, and then you start looking into that. So it's a challenge for me also. When somebody said, you teach, I said I can teach 10 hours, but can I teach 60 hours? What the syllabus I can draw? What the outcome of the student? And I feel very honored to say that many students who has done the courses are working in the field of refugee law. So that is the outcome, learning outcome based education, learning outcome based education. So वो learn किया, outcome मैंने education, and then he got an employment on the institutions which are working exclusively in there. The student have learned, he got the scholarship on the basis of the knowledge he acquired in the classes. So that is the outcome. Skill you have developed, knowledge you have developed in the student, and not only supervision. A teacher has, while mapping the syllabus, what I always see, I notice a ideological leaning. In many cases, we all are affected by our ideology. कहीं ना कहीं कुछ ideology का चाहे left, right or center. So teacher has to be neutral. यही बात है जो मैं पढ़ा रहा हूँ. तो मुझे हमें क्या पढ़ाना है law students को? We have to keep in the mind. You have to teach law as it is, and you can also go in the next stage. कि what law ought to be. हमें ये सिखाना बच्चों को. हमें ये नहीं कि उनको एक तरह से ट्यून करना है कि state is arbitrary, state is brutal, state is like violating the rights of government. We don't need to go. These are the political discourse we'll take. We have to prepare that. If they want to pick up whatever form they want, they can do that. But ideological leaning of teaching, it's a create a danger, or it's like they saw the seed, danger seed among the younger minds. Only one scenario that. And that's a huge challenge also. The society is not so much evolved. I have come across, and also like yesterday I was talking to a girl. She wrote a very good thesis, crime and emotions. The topic she chose, Nero law, crime and emotions. She wrote the thesis. So when the thesis came to me and then she came close to me also. So I said, this thesis will create problem for employment for you throughout your life. Though you have written very good work. पर बोले क्यों? हम बोले कि जो भी जज करेंगे आपको यहाँ पर बैठ के इस तरह, they are not aware, they see the criminal law in the what BRS में लिखा है वो आपके crime and emotions को link करके and then mitigating, so that will be very difficult. So you will deny, and that happened to her. 2-3 places she could not make it. Finally she made in the one of the Indian Central University. So what I advised her, she called me before the interview. I said, you simply say, you don't discuss about your thesis. Because thesis is your dangerous thesis. It will not help you in securing a job. Because the person they are traditional. Maybe when you people become on the same stage after 10 or 20 years to 25 years, then things may change. But are we traditional versus modern? So the concept of criminal law, crime and emotion is not so much accepted in the society or in the criminal law. So nobody, neither students nor teachers are. So I said in the interview, you just focus on the criminal law, traditional. If somebody asks you what thesis, then you talk about the thesis. Don't start with this thesis. So she followed and she got a job on one of the university. But in other universities she could not make it. In Delhi, she said the same thing. I said कि आपका प्रॉब्लम नहीं है, जो उधर बैठे हैं वो नहीं समझ पा रहे हैं आपकी बातों को, तो हमें कोरिलेट करना है सोसाइटी में. So when you write something, when you read something, you have to think about your audience. In this syllabus में भी है. जैसे सुबह में चार बातें सर के लिखा है. As a teacher, what just Professor Rao said, lifelong learning. So we have to be always in the learning mode. We have to always focus on the black and white. We can criticize the judgment. We can look into the judgment. We have to have that approach. Like, if you teach constitutional law. So I was very critical when on 8th April 2025, I suggest you people also to read the two bench judgment on the power of the governor, Article 200 and 201, was questioned by the two bench judges, 8 April 2025, about the Article 200, the state of Tamil Nadu versus governor of Tamil Nadu. That is the case, state of Tamil Nadu versus governor of Tamil Nadu. That case actually discussed about Article 200, power of the governor. So when we look into the Article 200, we see the governor has three important powers. He gives the assent to the bill, he decides to send it back with certain suggestions, the second step. So first is, he gives the assent to the bill without his sign करके. Second way, he may suggest कि some modify करो and then you send the bill. This is the second. And third, he consider it to the referring to the president. The third part is there in the Article 300, Article 200. The court has, and there are a number of questions which we have to think, which I also learned by reading this second judgment. So court has said, now this Article 200 and 201 is not an ordinary article. So two judges decided, governor has to decide the matter in a time framework. The governor cannot sit over indefinitely. Constitution is silent. Constitution has not said. Constituent Assembly did not speak any about the length of the holding of the bill. So it's a given power to discuss. So some logic might have been there, but court said, you can't do that. And court also, what court said, there are 10 bills which were pending with the governor. Court said, It's a deemed to be passed. A bill has been passed. So the court also said, governor power is limited. They have to 3 months करना है, नहीं करेंगे. And 10 bills which were the bone of contention were pending before the governor. Court said we pass an order. These 10 bills are deemed to be passed. So court has passed. Governor rule has passed. What is the next stage? Next stage is you go for review. Or so agar party is not happy, they can go for the review, and then even for the review you are not happy, the last stage is curative petition, and the third is the curative petition. So what government has done in this case? Government has not chosen review nor curative. What government has decided? President has referred 14 questions under article advisory opinion. So Governor President of India has a power under Article 143 to give his opinion about the, and then government has put 14 questions. Out of the 14 questions, Article 200, 201. So this become a big party. The lawyers representing the state, they argue this is like a way of skirting the procedure. In case government is not happy, government should have gone for the review. But advisory opinion regarding the Article 200, 201 is to undo the judgment of the 8th April. So finally the judgment has come. So you read the both. The first one is the 8th April and second is the 20th November 2025. क्या आप सीखेंगे अगर अपने जजमेंट को पढ़ोगे तो उससे बहुत नॉलेज बनता है. अब नॉलेज में से क्या हुआ? I came to know that there are 15 occasions the President has asked opinion of the court on 15 occasions under Article 143. Out of 15 times, the President has sought advisory opinion from the court under Article 143 till date, 14 times it's not binding for the court to give advisory opinion. Out of 15, 14 times later, court had accepted and given advisory opinion. Except in 1993, that is related with the Ram Janambhoomi, which court has declined. So ये भी पता चला कि 15 हो गए. So अगर हम पढ़ा रहे हैं वहाँ पर क्लास में, तो ये बातों को यदि हम वहाँ पर लाते हैं, तो इस बिकम एक वेरी लड़के को पूरा पता चलता है कि advisory opinion क्या है, how many times it has been taken by the governor, 15 times, why it has been denied. तो वो चीजें हम इससे पाते हैं when you read in the actual cases, and I am suggesting you to read. There are a lot of questions which are being answered there, which we may not be aware. कभी-कभी सभी मैं आपसे पूछूंगी, विशाखा की इसको पुत्तस्वामी judgment, है ना, पुत्तस्वामी judgment. So if I ask you why पुत्तस्वामी judgment was decided by 9 judges bench, why not 5? Why not 7? Why 9? एक क्यूरियोसिटी तो होनी चाहिए ना कि क्या मतलब क्रिटिकल थिंकिंग होनी चाहिए हमें. तो एक क्वेश्चन आता है कि क्यों इतना बड़ा बेंच के बाद पड़ी हुई मैटर 9? This could have been decided by 5. What was the reason? As a teacher, it's become obligation for us to also our duty to understand. Court has also duty. The question which I have in my mind, court has answered in the very first page. Ki why it has been decided to place before the 9 judges. So court had no option. Court had actually elaborated. हम तो ये नहीं पता लगाए. The court says कि there are different constitutional benches judgment which comes into conflict. Some 7, some 8, and different opinions. Some 5 judges benches about to right to privacy. So this is a conflicting judgment, and in fact 5 judges judgment have become norms which is practiced. MP Sharma case I think 1975. So they said this conflicting judgment, so all time it has to be settled. So now we have to go to the 9 judges bench, and that is how, because the conflicting judgment prevailing in for the number of years, and that is the reason it has to. So you get the facts. You know the facts. Important. Yesterday I was also on a very important subject. I was saying the right to seek compensation. It can be a complete class A complete course can be like, but it requires a lot of energy and critical thinking. You can't make it like access to justice can be a detailed class, detailed course. Right to compensation can be a detailed course. But for this you need lot of thinking कि कैसे इसको 40 hours को हम develop करें. अब right to seek compensation में भी then also relationship between international law and municipal law is equally important, where one can teach more the 30-40 hours classes using the case laws in India. On the basis of the yesterday's lecture, so I was also participating along with one Sri Lankan lady, professor. She mentioned, and then the discussion was focused on the implementation of the International Covenant on Civil and Political Rights, that convention. Both countries, dualist country. So it's like, domestic law prevails over international law. International law will become effective only when transformation of international treaty in a domestic law, then it's become effective. Otherwise, it remains not binding on the code. Technically not binding in the code. So what provision we have on the Constitution? Constitution says Article 253 of the Constitution. So relationship between international law and domestic law. The Constitution says Article 253, which talks about passing of enabling legislation. Passing of enabling legislation. So article, when it clearly states international law will become law of the land if Parliament passes that law, that treaty by the party effective passing of enabling legislation. ये तो प्रोसीजर है कॉन्स्टिट्यूशन में, हाउ इंटरनेशनल ट्रीटी ट्रांसफॉर्म्स इन द डोमेस्टिक लॉ. एक दूसरा है कि हाउ कोर्ट लुक्स इनटू द इंटरनेशनल लॉ. अभी आप इसको जब पढ़ाने के अब चलते कोई टीचर भी, इफ यू गो इनटू द विशाखा जजमेंट, विशाखा जजमेंट वर्सेस स्टेट ऑफ राजस्थान 1997 की जजमेंट है, AIR 1997, SCI 570 So 1997 में and these are the judgments you should learn, you should read. I would not advise you to read Puttaswamy judgment because 900 pages वो क्या लिखते हैं कि आपको पता ही नहीं है. तो to make everything effective, you don't need to, because but Visakha judgment is only 10 pages judgment. Justice J.S. Verma somewhere believed in the brevity. तो हमें भी एज ए टीचर तो जब हम पढ़ते हैं तो उसमें आप पढ़ लोगे 10 पेज को और बच्चे को भी पढ़ने कहेंगे तो वो भी पढ़ के आ सकता है. सो ही मेड ए पॉइंट व्हिच वी और स्टिल 1997 कितना इफेक्टिव कम्युनिकेशन है, कितना उसके आउटकम कितने रीच है. ही सेड द कोर्ट विल लुक इनटू इंटरनेशनल ट्रीटी in the lens of the constitutional perspective. If international treaty speaks about same thing which constitutional principles highlight, so we have no reservation in implementation of any treaty if it is more or less available in the international treaty. So if it's like it matches with the constitutional principle, constitutional norms, we have no hesitation in implementation. So court, what court has done? Court has not looked into the Article 253 of the Constitution. अब इसी केस में court has mentioned about the CEDAW. The main जो guidelines बना, court has taken root from the Convention on Elimination of All Forms of Discrimination Against Women, CEDAW. What court has said? The government of India has failed to implement CEDAW Convention because it did not adopt relevant laws which ends the discrimination against women. So non-compliance of CEDAW Convention, court had observed. अब government तो ये कह सकती कि no, we have not adopted a domestic law under Article 253. CEDAW has not become The treaty of the law of the land, because we have not passed enabling legislation. We have accepted legal obligation. We have ratified, but CEDAW has not acquired the status of domestic law because passing of enabling legislation has not been done. Government could have said, but could say, nothing doing, so you have an obligation. So court moves independent of the constitutional provisions and its own way, and that is more progressive. And since court has said, since you have not done, we will not wait for you to adopt the law, we will make the guidelines under Article 142 of the Constitution, and that guidelines will be applicable till you adopt the laws. तो बाद में डोमेस्टिक वायलेंस एक्ट आया 2005 में, and then Sexual Harassment Act 2013. So court has more progressively looked at. So a teacher teaching a law, well, he teaching the relationship between international law and municipal law, relationship between international law and municipal law is an important topic of the public international law. So when you teach that, you have to bring that. So you are preparing your students in a manner where he understands the constitutional strength as well as the implementation of international treaty. You could have avoided. You said, what is the difference between relationship between transformation, other thing, without going into the cases, without looking into the, because you only read the Malcolm and Sir, you only read the Star, so you never read the Constitution. You never said, you said you believe you are the teacher of international law. I have to read only public international law. So what Malcolm and Sir says, that is the final. But implementation is important. So what you said, my syllabus mapping how international law through the court is implemented in India, that narration will make your mapping of the syllabus much wider compared to that. So it also allows you, it also permits you to understand international law and also the constitutional law. We have never been taught like that. I have also realized later on when we studied, we have never been taught like that. Even constitutional law teachers told us how international law has to be looked. So gradually we pick and we say that it has become very interesting when we look into the international law with the prism of the court, decisions of the court, and then we go into that particular thing. Then another important case which I would like you to read also, Nilavati Behra versus State of Odisha. Nilavati Behra versus State of Odisha. This is equally another landmark case. क्यों है landmark case? Any idea?
Custodial.
Custodial देख लो था, देख लो उसके बाद
कंपटीशन कर रहे हैं. Police guidelines. Police guidelines.
हाँ, पुलिस गाइडलाइन तो नहीं था, compensation. That's a important is the compensation. The compensation is not the first time it was granted. Compensation was granted first time if we say it start from compensation was granted, but not in 1993 is the first case, 1993. It was granted Dudulsa versus State of Bihar in 1980. Dudulsa versus State of Bihar, then Hussain Thakur, then Saheli, then PUCL. You have series of cases where court has granted compensation. But prior to Dudulsa, court was hesitant. Court was not granting compensation. Why? So compensation was always granted only on those cases where public officials were involved. Failure of public officials, government officials. But this is not from the very beginning. So क्या था problem? The concept of sovereign immunity. The concept of sovereign immunity was upheld. While the public officials, they discharge their duty on behalf of the sovereign. While discharging their duty, They should not be made accountable for any kind of violation of human rights because they have immunity. The concept of sovereign immunity was upheld in many cases, and then most landmark case, Kasturilal versus Rangialal case, Kasturilal versus Rangialal, where the concept of sovereign immunity. So like public official to काम ही नहीं करेंगे. If you said no, you have no immunity. So while discharging their duties, knowingly or unknowingly, if they make some mistake, they should not be held accountable for violation of the rights. Court said, they are equally accountable. Nilavati Behra, why I have brought? In the Nilavati Behra, the first time Justice J.S. Burman has used the provision of the International Covenant on Civil and Political Rights, particularly Article 9, Paragraph 5. Article 9, Paragraph 5 of the International Covenant on Civil and Political Rights. Article 9, Paragraph 5 of the International Covenant on Civil and Political Rights. Article 9, Paragraph 5, it talks about, so it's a part of human rights instrument. So it's a part of the global international human rights instrument. So 9, Paragraph 5 says, in case of illegal detention, victim has a right to seek compensation. So right to seek compensation is integral part of International Covenant on Civil and Political Rights mentioned under Article 9, Paragraph 5 of the Convention. India became party of the International Covenant on Civil and Political Rights on 10th April 1979. So we have accepted legal obligation. We are bound by this treaty. 10th April 1979, we decided to become part of this instrument which I am talking about, and which has Article 9, Paragraph 5. But what government has done in year 10th April 1979, the government had said, we don't have any laws related to the Article 9, Paragraph 5. Government officially has stated, we don't have a similar provision in Constitution or any other law where victim can seek compensation. So means we expressed our reservation. We said we will not apply Article 9, Paragraph 5 because we don't have any law in the Constitution or any other law where victim can seek compensation. So what we have done, we have made a reservation regarding the application of Article 9, Paragraph 5 of the International. So officially we have made reservation, non-implementation of Article 9, Paragraph 5. ये हमारी सरकार की पोजीशन है कि हम अप्लाई नहीं करेंगे, हमारे यहाँ लॉ है ही नहीं राइट. तो आप देखो 79 में कोई कंपनसेशन का सरकार कह रही है कि हमारे पास कोई कानून नहीं, we don't have any law. अभी आपको बोल रहे हैं कि बहुत सारे कंपनसेशन में केसेस है. So it has evolved to the judicial interpretation. Government has said no, nothing doing. We have no right to. So government believes and government followed the concept of sovereign immunity. Globally also we have stopped. We said no, we can't implement. But gradually through the court constitutional thought, we started granting compensation. We have series of cases where we have granted compensation. The reason for bringing this mobile is unknown. The reason for bringing this case, Article 9, Paragraph 5 in the Nilavati Behra versus State of Odisha, Justice J.S. Burma had cited Article 9, Paragraph 5. He did not look into the reservation of the government. He said that Article 9, Paragraph 5, the government of India has an obligation to pay compensation to the victim because India is a party to the International Covenant on Civil and Political Rights. Though the position of the government of India is contrary, court has interpreted it positively. Government has negated that. Government said no. But court is not going on the intricacies of the state executive measures, reservation, declaration, other things. Court only looks into the essence, thrust, objective of that particular convention, and that is the reason I am saying Article 9, Paragraph 5 has been referred in the Nilavati Behra versus State of Odisha case. Let's 3-4 point when you draft the syllabus, you have to look into. You always focus on your students. अब ज्यादा हेवी सिलेबस भी हम करते हैं मॉडल 1 में कोई भी यंग टीचर हो गए इतना चीज बना के लिए आएंगे लग रहा है कि वो घर में हो गया कि चलो इतने ज्यादा कि आप खा नहीं सकते उसी तरीके के सिलेबस में आपने पूरा मॉडल 1 विल कवर दिस मॉडल 2 तो यूसे की तो बहुत दिन लगेगा so syllabus should be also objectively drafted in a manner which can be completed in a stipulated time. एक तो पहला don't jump, don't try to prove a point, I can draft a bigger syllabus. A syllabus is a real syllabus, actual syllabus, which can work. So when you are drafting a course curriculum, you always keep in mind, even if Vice-Chancellor said कि उनको नहीं पता था Vice-Chancellor को, मैं सोचूं तो Vice-Chancellor भगवान है, ऐसे कुछ नहीं। आप अपनी बातों को सबसे बड़े जो यंग जनरेशन में खतरनाक चीज है कि they don't defend. अगर पीएचडी का भी आपको यहाँ मैं बैठा दो और किसी भी टॉपिक पर आप बोलना शुरू कर दो तो हमें तो भी प्रूफ करना है कि हम भी पढ़े लिखे आदमी तो वो कुछ उल्टा उल्टा हम बोलेंगे and then you say कि I'll change. You should not change. If you are convinced what you have written and you can, so you have to defend. तो थीसिस में ज्यादातर समय में कई बार बच्चे अपने स्टूडेंट्स को भी देखे हैं कि जब टीचर हम बोलते हैं कि बोले कि why you change? Because you have been working, you have read. And if you are not satisfied, then don't come on the dais. If you are fully prepared, so you prepare. So you make a syllabus, you defend your syllabus. So when this reasonableness. If you are convinced your syllabus is working, your syllabus is reasonable, your syllabus is outcome is the knowledge, is skill and sufficiently covered, then you defend. Maybe it's like head of the institution or any senior professor will ask. You say that these are the points I believe I can cover. Beyond this may not be possible and irrelevant also. If some good point comes, you take. But don't destroy your home because somebody says, 4 stories is better than the 2 stories. So you're like, so you lose 2 stories also and then you'll never get the 4 story. So continue whatever you design. So you are the architect of your syllabus. You believe. क्योंकि ये आपको मिलता है जहाँ इलेक्ट्रिक पेपर्स में you are architect, so you have to plan and you have to plan according to syllabus. Syllabus should be simple and easily conveyed. कि क्या टॉपिक कन्वे करना है is there. And use this simple language. It should also provide, when we talk about the syllabus, a detailed reading material also. You can always increase. Reading material में कुछ अगर नई बातें आती कोई नए लोग कहते तो you can take. If your teacher suggests or supervisor suggests, VC suggests, reading material can be as long as possible you can. So syllabus has to be working. And so क्या कि knowledge it can convey a knowledge, it can pass transformation. You are the person who transforms the knowledge from one to the another. So whether it's going to register in their mind at that. So effective syllabus is important in drafting there. So what is important? You have as a teacher, you recognize, identify and unique quality of each student in your class. So when you start teaching, you have to. Your syllabus should have also flexibility. There is scope of some kind of modification. Flexibility is also there. And since we are discussing in the context of national education policy, the curriculum, because national education policy focuses on more on the holistic education, multidisciplinary education, holistic education. So I feel in multidisciplinary education, so you can't how much multidisciplinary or interdisciplinary. There are 2 approaches, interdisciplinary or multidisciplinary. Multidisciplinary not merges. Multidisciplinary approach remains independent. Interdisciplinary approach merges. So like history, historical, economic, they all remain independent interpretation. But interdisciplinary, so हम कहते हैं कि interdisciplinary law in society context, law in economics context, law in the philosophical context. But not law should be studied in all the contexts for one subject. Then it's become independent approaches, multidisciplinary approaches. There's a distinction between multidisciplinary and interdisciplinary. So we go more on the interdisciplinary approach in the drafting of our syllabus. Of course, as a syllabus, it must deal with the conceptual understanding. Conceptual, theoretical understanding is equally important in part of your syllabus. It has to be there. We have discussed about the life skills. So like what you are teaching, it's a lifelong is there. Now we are also passing, so in your class you are teaching, you also try to see how technology can be used, extensive use of technology. You are not only teaching that, अभी जैसे हम आपको पढ़ा रहे हैं, use of technology is very important. हो सकता है वीडियो लाना हो सकता है फिल्म दिखाना हो सकता है कि हाइपोथेटिकल क्वेश्चन करें, तो आपको टेक्नोलॉजी, क्योंकि आपके सामने जो बच्चे आएंगे वो पूरे टेक्नोलॉजिकली एक्यूप्ड है। हम लोग के समय तो अभी होता है प्रॉब्लम, बट वी कांट चेंज, बट यू आर इन अ पोजीशन टू go parallelly with the development which are happening today. You have age, you have a time. So the use of technology is very important in the classroom teaching. And जो more important part है, जो anything light but tight, हल्का भी है but लेकिन tight regulatory framework पे इसको हमें syllabus को करना है. And then also in the course curriculum, which I differ from many teachers, the continuous learning process. है ना कि आज के evaluation के assessment से बनता है कि continuous evaluation भी करना है. वो क्या रहा है, कंटिन्यूअस इवैल्यूएशन क्या हुआ कि पहले होता था कि एंड सेमेस्टर एग्जामिनेशन में यू आस्क 100 नंबर क्वेश्चंस एंड स्टूडेंट पे, देन दे सेड कि ना इवैल्यूएशन का शुड बी कंटिन्यूअसली अटेंडिंग इन द क्लास, प्रोजेक्ट, participation in the activity. So 50 marks should be on the different ways and 50 per the there. In many schools, so idea was, so a student can compensate one side from the other side. That is the other final result they combine. अब बहुत सारे colleges में क्या कर दिए हैं कि you have to pass in the project and you have to pass in the end semester examination, and then we club your number. So if you pass like in end semester examination, you fail in the project, you have not passed in the paper. So it's like it's a harming more than helpful to the students. The idea behind introduction of the continuous evaluation to assist the student to pass, and that is the reason. So even if he got only 40 marks in the class assessment project and in the end semester he gets 10 marks and 12 marks, by adding he passed that paper. But today many law students, but I see and I suggest you follow that approach. In your paper you say, of course the administration wants to do that, that is the, but like you depend, the idea behind continuous assessment to support the students, not to create double barrier. So what is happening, it's creating double barrier. You asking them to pass in the project independently, you are asking them to pass in the end of the examination. So these two are not related. So I feel it has to be one, and that you have to see about that. Just last point which I'll say, that sir will come. So learning based, what I have taken from the NLP, it says learning based outcome education and assessment advocates the importance of establishing a clear picture of what is important for students. A clear picture. So learning based outcome education and assessment, clear picture of what is important for students to be able to do, organizing the curriculum, instruction and assessment to make sure that learning ultimately happens. And important points under the learning-based outcome education and assessment are, ये 3-4 पॉइंट आप लिख सकते हो. Define exit outcomes. Define exit outcomes through active participation of all stakeholders groups. Define exit outcomes through active participation of all stakeholder groups. Second, redefine performance. Redefine performance and students to provide redefine performance, and standards to provide regular reports as actual student learning levels in all key outcome areas. Third, develop high engagement / high activity classrooms stuffed STUFFED by variety of internal and externals, continuous emphasis high technology tools and applications. The learning outcome based education, LOPE, learning outcome based education LOB, learning outcome based education. The core philosophy of LOBE, the core philosophy of learning outcome based education rests in adhering to student-centric learning approach. Student-centric learning approach used to measure the students' performance